Hi, I'm Nicole Hemrick, and I'm the founder and managing partner of Hemrick O'Malley, PLLC. Today, I'd like to discuss a question that we hear quite a bit, and that is, who should file for your child if you are a green card holder and your spouse is a U.S. citizen? First of all, let's do a little reminder as to who is a child. A child is anybody who is under 21 and is unmarried. And the child will also count as your spouse's child as long as you married your spouse prior to your child turning 18. While many people would prefer to file for their own biological child, it actually makes more sense for your U.S. citizen spouse to file for the child. Why is that? That is because if a U.S. citizen files for a child, that is considered an immediate relative petition. And once the I-130 from the U.S. citizen is approved, there is no waiting period for your child to obtain a green card. In fact, if your child is here in the United States with you, your child would be able to file for his or her green card at the same time as your spouse files the I-130 petition. If the child is abroad, as soon as the I-130 petition is approved, it'll be sent to the National Visa Center, and then the National Visa Center can immediately start processing your child's immigrant visa. On the other hand, if you, as a permanent resident, file for your child, there is a waiting period. I'm going to just share my screen with you briefly. The waiting periods for anybody who is not the immediate relative of a U.S. citizen are dictated by something called the Visa Bulletin, which the Department of State puts out on a monthly basis and basically estimates timeframes based on how many visas are available in specific categories at any given time. Here is the Visa Bulletin, and you can access this by either putting in your search bar Visa Bulletin, that's what I normally do, or you will see the URL here, https://travel.state.gov. There are two different charts here. One is final action dates for family preference categories, and that is when your relative can actually get the green card or immigrant visa, which is getting the green card from abroad. And then there's the dates for filing, and this is an earlier date where you can actually start processing the case, meaning, file an I-485 if the child is here, or file a DS-160 immigrant visa application if the child is abroad. As you can see, the category for unmarried children of permanent residents is F2A. This isn't bad. You'll see here you can file as long as the I-130 petition had been received by USCIS July 15th, 2024 or earlier. But if you look here under the final action date, which again is the date that your child can actually receive a green card or immigrant visa, they're all the way back to January 1st, 2022. So that's a 3-year wait. Based on this, bottom line, if it's possible, it's always best for your U.S. citizen spouse to file for your child. If you have questions about this or any other immigration matter, give us a call at 833-848-7838 or check us out online at www.hemrick.law.